As soon as I come back from vacation, y'all put me to work. My God, I love y'all. I did enjoy myself, and I'm glad to be back with you. I just got off of 2 really cool lives. A lot of you asked a lot of great questions. But for those of you who haven't tuned into the lives, I've got a quick update. We have 2 new filings in the court docket related to Akira and Brenay's lawsuit and the appeal. We're going to break that down, but first, certified law nerd, bona fide non-attorney, this is not legal advice, just my interpretation of what is going on in the court record. Let's begin. A lot of you were anxiously waiting to see whether Brenay posted the $40,000 bond that was set to allow for a stay on collection of the judgment against her. As I said a few days ago, if nothing reflected by the next business day, Monday, it was safe to say a new writ of execution would likely be filed. Well, Akira and her team wasted no time. We have a new one. The most notable difference is that the amount has already grown to $1.816 million, which includes the $65,000 it has accrued in interest since the judgment was entered, and the exemption list is now attached. I'm not showing that in this video just because it's got a lot of info and too many pages. So that is a required step. That notice of exemption and that exemption list is a required step before the sheriff can act. That is my theory on why the earlier writ of execution was not issued. So for those who haven't seen my many videos on this, collection on private civil judgments in North Carolina usually come through lien and levy. A lien is the judgment attaching to certain property interests like real estate. Okay? Real estate that there is equity on. A levy is the enforcement step where the sheriff can seize non-exempt personal property, such as household items or physical property, or liquid funds to help satisfy the judgment. Now, a big question that's circulating again. Can Brenay file bankruptcy? The answer is yes. She can file bankruptcy, y'all. Remember, bankruptcy is a declaration of all of your debts. The question I think you want to ask is, can this specific judgment be discharged in bankruptcy? And based on the nature of this judgment, the answer is likely no. You see, there is an exception in bankruptcy code that accounts for debts that are related to willful and malicious injury. And historically, alienation of affection judgments fall into that category. So this would most likely, almost certainly, not be discharged through bankruptcy, but she can technically file for bankruptcy for her other debts. Another question is, can she try to evade collection by moving money around? I mean, technically, yes, you have free will. Does that come with legal consequences? Also, yes. Courts tend to frown when money starts playing hide and seek after a judgment. There are plenty of legal avenues that can be taken to get her to either disclose where her money's going, who it's going to. Could there be legal consequences if somebody's helping her move that money around? Could it constitute fraud? All of that is possibly yes. But again, let's not put the cart before the horse. It's just if she chooses that route, it could come with legal consequences. The most immediate impact in Brenay's case, in my opinion, would likely be through the levying of her bank accounts. That means the sheriff can serve the writ on a financial institution. And if there are non-exempt funds, which we've seen the exemption list, money is not there, if it's in an account belonging to Brenay, those funds can potentially be frozen and turned over toward the judgment. This is where the exemption paperwork matters, because not every dollar or item is automatically fair game. We've already seen what she has asked be exempted. Anything outside those exemptions, though, can become part of the collection process. So what happens next? Well, this is the actionable phase. This is where the sheriff goes to work. They've received the writ of execution, which is a command to the sheriff to go and collect on behalf of the creditor. At the end of the day, it's just about finding accounts, finding property, finding what titled property, if any, belongs to her, can be seized or auctioned off. And unfortunately, it really is the end of the road. This does not impact her ability to appeal. This is a question I keep getting. She can still appeal. Whether she'll have the financial resources to continue this lengthy, expensive legal process, that I don't know. But she is still legally allowed to appeal, and that is still ongoing in its preliminary stages, which we have seen a motion to extend time. So come back for the next video. I'll do a quick breakdown on that. I'll catch you in the next one.